child has a diagnosis, like, are they safe? Like, so, or can the school say, well, we'd like him to be reevaluated to see if he's still on the spectrum? Like, you know what I mean? Like, if they already have the diagnosis, are they safe?
Yeah, I actually, this is a more complicated issue that's gonna, but, I mean, obviously you would say, well, what is the standard? When was the standard applied? And then you'd get into a whole host of issues of them trying to apply a standard retroactively, but you have an annual process and you have a 3-year reeval. So all of those things would come into play, but we're not there yet, and hopefully we're not going to get there. So just bear with me because it is 8:45, so I want to see if I can get through the important points that are still here. So I went over the eligibility, the annual, the 3-year, the team membership, who needs to be there. That's on page 11 at the bottom. So you want to have your child if appropriate. You know, once your child turns 14, they encourage your child to attend because we're going to be developing a transition plan based on their preferences and their interests. So if it's appropriate for your child to attend, I mean, I would say to parents, use your own judgment in those circumstances. We all know our children. You don't want to invite them to the meeting if you feel they're going to be upset by it. You can certainly get their input in advance. They could write a statement and participate that way. You need a special education teacher, a regular education teacher, someone who's knowledgeable about the district resources. So that means you want a team chairperson or some other administrator. So if the team's making a decision on services that your child needs, that the district's going to have those resources and commit to providing them. Again, if evaluations are being discussed, like a 3-year reeval, someone who can interpret and explain those results for you. And then you can invite anybody that you want to come with you. Some people bring, family support workers, respite providers, experts that you may have working with your child. What I always suggest that parents do when they go to an IEP meeting is to take at least one person that's not you or your husband or spouse or partner, that you want to bring somebody that's, a friend that's really good at taking notes. Because you're going to be focused on listening to what's going on around the table. You're going to be, trying to respond to what people are saying, and you're not going to take very good notes because you're going to be involved in the discussion. So it's good to bring someone along that can take good notes for you so that you have a record of what transpired at the meeting. Now, I'm not suggesting that that's a record of the meeting, but it is your own set of notes. Before you leave the team meeting, you're going to get a copy of a team summary sheet that's going to list out what was agreed to by the team. So you want to list out the services that have been agreed to, the goal areas that were discussed, things like whether your child needs a one-to-one, whether your child needs transportation, all of those things that were discussed and committed to. You want to get that in writing on the team summary sheet because it is what reflects what happened as a result of that team meeting. They're not going to actually hand you an IEP when you leave the team meeting. There might be a draft for discussion purposes, but the actual commitment is what's on that team meeting summary sheet until you get the IEP for your review. Okay? So make sure you get that meeting summary sheet because people's memories do change. So you might want to make sure that everything is listed on that before you leave the building. So if there is a question, you can go back to the team chairperson and say, this is missing, or, go over it before you leave. Don't just get a copy. Yes, sir?
Is the district representative supposed to be the special ed coordinator, or the chair of the meeting? Is that the same person, one and the same? Or do you think that should be a different person?
It generally is the special ed coordinator, the team chairperson. I know that depending on what's being discussed, it's required to be there. It's not up to you to have that person there. It's up to the district to have that person there. So they're required to have somebody at the meeting who's authorized to make decisions on behalf of the district.
Make decisions about what resources are available, or be knowledgeable about.
Right.
Because they sometimes, I wouldn't necessarily meet that bar. I would say.
Sure, you're right, sir. Yes.
In summary, you have to make sure that you read it, and they're there, if you have any questions. Suppose
Well,
you
I
can't
do,
get-
because,
No, suppose you can't do it. You still have the right to question
Well-
what's in there afterwards?
You can question it afterwards, but it's a record of what just happened. So what I'm saying is, before I leave my meeting, I look at it. Really what you're looking at primarily is the services and any other things that are unique, like, you know, transportation door-to-door with monitor, stuff like that, a one-to-one aid, sort of the big issues in the IEP. They're not going to give you an outline of like all of the goals and benchmarks, but
If the IEP is silent, right? What does that mean? Silent course, is that entitled?
you're not entitled, well, if it's on the summary sheet, it has to be in the IEP.
It's not on there.
The summary sheet is a commitment. It's in writing from the district, so,
But if they don't make it,
well, that's a dispute issue. If you get something in writing that the team has agreed to, that's a commitment. And if it's not provided, then that's a compliance issue, meaning that they're not doing what was agreed to. If you ask for something and if they don't agree to it and they don't offer it, then that's an issue of dispute. That's something that you would need to appeal, that decision process, okay? But if it's in there and it's on the summary sheet and then it's in your IEP and it's not happening, that's a compliance issue. So, moving on for team membership and bringing your good note taker to your meeting. Next part talks about the role of the parents. So it's always saying that another thing that has to do with your IEP process itself is part of every IEP are the parent and student concerns, the student strengths, and the vision statement. I always take the time before my child's IEP meeting to write out my parent concerns. So at the team meeting, I just give them to the team chair. You can email them to them if you want them to be incorporated. Nobody gets to change your parent concerns. They're yours alone. If your child's older, you might want to have them express their concerns and include those in them. But those are yours to be included. The vision statement is more of a team vision statement. What would you like, what do you see happening in the next 1 to 5 years for the child? If the child's very young, I say stick to like a year's time because children change a lot in the early years. But after that, you want to be looking forward several years. You know, what do we want this IEP to be focused on? What is it that we want to see achieved in the next several years? You know, I want Mary to be reading given the supports and services that she requires. I want her to be reading on grade level and, having friends and, whatever her individual needs are. You're sort of looking forward and what do you want them to be able to achieve. It's hard for me because I have a different type of child to sort of speculate for you guys, but I think that since you know your children best, you're able to develop what that should be. Sorry, I can't read anything without my glasses, so that's why they're off and on a million times. This just talks about the parents, the transition planning is next. When the child's, so age 14, we start transition planning. Again, there's the website that connects you to a link for Mass DOE. At 18, there's an age of majority. That's something that you want to know about and plan for in advance because automatically by law, your child will get their own rights when they turn 18 years of age and they will be in charge of their IEP. You can have your child delegate that decision-making authority to you, and then if your child is significantly impacted by their disability, like my child, you would want to be planning in advance of their 18th birthday to go to court to get a guardianship, which would put you responsibility for all legal decisions to be made for your child having to do with their finances. Some kids will require sort of a partial guardianship, so you really want to look at that issue of you don't want that 18th birthday to kick in and all of a sudden these legal rights are flowing to your child and they're able to make decisions that quite frankly are not in their best interest and that you want to protect them from. And if you have legal guardianship, that will address it in terms of the world in general in terms of decision making. But for the IEP process, you can have your child delegate that decision making authority right back to you. You can also have a shared decision making when the child turns 18 so that there's an agreement that that will be discussed and it won't just be the school talking to them directly and not talking to the parent. So if people have children approaching that age, that's something to think about. So the team membership, if there's someone that needs to be there and you agree, but they're sick or, they can't be there and you agree that you want to have the team meeting without them, You have to agree that if somebody's required to be there, you have to give that to them in writing, that you agree to that. It's really just saying, you can always reschedule a team meeting. If someone needs to be there and that person's not there, you find out that day that they're out sick, reschedule the meeting. If you feel they're important and their input's important because they know what your child's needs are, just simply reschedule the meeting. Next part just talks about getting organized yourself, what you want to create for yourself. You know, an IEP notebook, keeping everything. You know, it's nice to get a 3-ring binder. You get the IEP, you put that in. You know, if there were any evaluations that year, you put that in. As the progress reports come in, you want to put that in. So when the next IEP process rolls around, you have everything neat in one place, ready for you to look at and review. Yes, Al?
Can I just ask about the membership? When you have a child that in the upper grades that has more than just their one teacher, you know, math, English, are they required to come to?
No. The question was, is as the children are in the upper grades and they sort of travel from different teachers, they're only required to have one regular education teacher and one special education teacher because, quite frankly, they're all supposed to know the curriculum, and that's really what they're to respond to, is sort of the curriculum that's being addressed at that grade level, and then what specialized services that child needs to be able to access and make progress in that curriculum. But they're not required to, but you can certainly ask that they come to the
Or
TV.
to have at least one teacher, because at my last one was no teacher. So
Well, they have to have a regular education teacher and a special education teacher, so that is required. So again, this is talking about being organized, how you get yourself ready for the IEP. It's really reviewing everything I just talked about, whether or not your child had the MCAS results and how that went. And strategies before the meeting is sort of to go through your documentation review. What is it you want to focus on in the following year? How did the child do? Where were the areas of growth? Where are the areas of lack of progress? The next part is really a reiteration of the team meeting process and the timelines. If your child's not eligible, okay, you can reject the finding of no eligibility and request an independent evaluation in the areas assessed. Every time the district does an evaluation and you don't agree with the results of the evaluation, you can request an independent evaluation for the district to pay for it, okay? There's two things there. There's sort of a sliding scale for the district to pay based on your family's income. And then under the federal law, you can request an evaluation. And if after 5 days they don't request a hearing, that their evaluation was comprehensive and complete, then they have to pay for the evaluation. So it's really, you don't want to request evaluations just for the sake of requesting them. I mean, it should be that you don't think the evaluation looked at the appropriate things. You don't think that the evaluation was comprehensive in terms of the information that it provided to you on the area that it was meant to assess. You want to look at, were there actual testing tools used? If an evaluation consisted of observations only, you know, that's not really objective information for you to look at. That would be totally subjective and based on the opinion of the observer. For some things that may be appropriate, but that's generally not going to be. You want to have standardized testing, and a variety of tools is supposed to be used to assess a child. I'm not saying a variety of tools need to be used in every area, but a variety of tools in assessing a child, you know, in terms of an entire evaluation. You're not going to use one test. And then services can't be removed or reduced without demonstrating that need. So this is sort of touching on, even though it's under not eligible. Once you get services in your child's IEP and you go to your, you know, say I have 3 times a week speech for 30 minutes, and then I go to my annual meeting and they say, well, we're going to reduce your speech and we're going to give it to you 1 time a week and you're not going to have it for 3 times a week. We don't think that's necessary anymore. And I say, I disagree. Well, I'm going to reject that IEP in part and say, I reject the proposed change to speech services, and I'm invoking my stay-put rights to the previous 3 times 30, and you keep the 3 times 30. They cannot change it without your agreement, because the thought behind that is that the team agreed that we need 3 times 30. The district's proposing a 1 times 30. The team doesn't agree, because I'm on that team, and I don't agree. So I have the right to reject that, okay? So that's for services that are already in the IEP. If you're asking for something, and the district says we don't agree that they need it, so it never got into the IEP, that's a dispute. So the difference is that under stay put, you keep it, and they have to prove, they have the burden to take it out. They would have to take you to hearing, but if it's not in there and you want it, you have the burden to show that it's necessary for your child to receive a free and appropriate public education, and that's where your procedural due safeguards come in, that you can request mediation, you can file for a due process hearing, those types of things. So there's a big difference there, but stay put is something that you should be aware of, because some parents don't know about that, and their child has services removed from their IEP that they're not in agreement with. The next slide is really giving us the difference on 504s and IEPs. What I will tell you is that if you have an IEP, you have all of the rights and protections of 504, okay? But if you have a 504, you do not have the rights and protections under the special education laws, because a 504 is not an individualized education plan. It's a 504 plan. So IEP grabs 504, it's all in there. 504 does not reach out and touch IEP, okay? Continuing of settings, this is just listing out the type of programs that exist. So we have full inclusion, partial inclusion, which the child is in the regular education classroom and environment for part of the day, maybe goes to the resource room, goes to the therapy room. Then we have self-contained classrooms. What that is that's substantially separate, where all of the services are provided out of the general education classroom. And then you move on to more restrictive environments if the team deems that it's appropriate in terms of day programs. The district has 3 day programs itself, like the Carter, the McKinley, and the Horace Mann. And then we also have collaboratives that are public day schools that are something that communities support together. And then we have private schools that go all the way up to residential settings. So I know our babysitters are done, so I'd say that with regard to sort of the rest of this, it's not limited to reading and writing. It has to do with non-academic and extracurricular activities. So if your child needs supports and services in order for them to be able to access field trips, to participate in recreational activities that are offered to other kids in the school, then those are things that you also want to address within the IEP process, okay? Timelines for the close of the meeting. As I said, you want to get a team summary sheet, and then you should have the IEP within 2 weeks. You can say that you want the IEP sooner, but I always say that I want it right rather than sooner and wrong. That's up to you. And then with regard to responding to the IEP, you have 30 calendar days, okay? Calendar, not school days. So it's shorter time for parents, it's always shorter for us. But you have 30 calendar days to respond to the IEP. You don't need to take the whole 30 days, so you can, accept it, partially accept it, or reject it. When you accept, services are to begin immediately, okay? Whatever you're accepting, so if you accept it in full, the whole thing's good, you're done with that. Reject in full, it's going to be very rare that I would ever suggest that somebody reject an IEP in full. First of all, if you're coming into the special education and you reject it in full, well, that just means your child gets nothing. They have no obligation to do anything if you reject it in full. A child turning 3 and you reject the whole thing, there needs to be portions of that IEP that are acceptable. Services that are offered, even on sort of an annual process, hopefully the goals are being updated and revised so that they're more appropriate. So you really want to look at rejecting in part and accepting in part. So you want to accept what's good, and then you want to reject and it says the following portions. You don't need just to limit yourself to the lines. You can include it on an attachment, either in letter form or a list, and include it with the signature page. I reject the following portions. You can reject by omission, meaning I'm rejecting by omission the 4 hours of ABA services that I requested and that were recommended by my child's doctor, but were not placed in the proposed IEP. So that's rejecting by omission. What did you ask for that's not in there? I'm not saying it entitles you to it. I'm just saying you're going on the record saying that you didn't accept that IEP in full. Because if you go into a dispute process, if you accepted it in full, they're going to say you don't have a claim that anything was wrong because you accepted the whole thing. Okay? So that's really something to look at in detail. And then separately from the IEP, you accept the placement or you reject the placement. There's not a partial there. You're either accepting the proposed placement for your child or you're rejecting it. You can accept the IEP and reject the placement. They're two different determinations that you're going to make, okay? And then your expectations once the IEP is signed. We have the progress reports, the annual review, the 3-year re-eval, and you have the right to access your child's records at any time. Amending or modifying the IEP, they can't change the IEP without your consent, but you can certainly agree with the district to change or modify the IEP at any time. It just needs to happen in writing. Consider the IEP your contract with the district, and it sets forth what's been agreed to. So you can't change that contract without the parties signing it in writing. And they certainly can't do that without your consent. The next part is about resolving differences. I talked about if you're in disagreement, you can request an independent evaluation from the district within 16 months of the time that they did theirs. I said if you disagree with theirs, well, after 16 months, realistically, they need to do another evaluation themselves because now you're looking at information that's outdated, okay? And one independent evaluation in each area that was evaluated. And then the next slide talks about resolving differences. You can get your own evaluations. And I talked about the fact that if they don't file for a hearing within 5 days under the federal law, they have to pay for the independent evaluation. But you should know they're only required to pay the amount that's listed in the state rates. So it's not like they have to pay the entire amount regardless of where you choose to go. It's based on the state rates because the law is trying to be fair and give everybody equal opportunity financially as well. Resolving differences, if there's a problem with your IEP, one of the options on the IEP signature page is to say, I request a meeting to discuss the rejected portions. This is your team, this is the people that know your child the best, and it is supposed to be a collaborative process. Try your best to work things out at the team level and come to an agreement. You don't want to get involved in any type of dispute process unless it's absolutely necessary. It's emotionally exhausting, it can be financially draining as well, and you just want to do your best to try to come to terms with the people that you're working with and who truly chose this profession because they want to serve your child and give them what it is that they need. If all of that fails, you do have the right to go to mediation. Mediation is free. It's an impartial party that participates in mediation, but that person does not have the ability to make any decisions. They cannot issue a decision at the end of mediation. It's really another opportunity for the parties to come to an agreement. Or you can file for a BSA hearing. That I would not suggest you do without hiring an attorney, and that is somewhat... The BSA hearing officers are authorized by law to issue a decision whether it's changes to an IEP or changes to placement for a child. It's a very long, involved, costly process that I would not recommend to anyone that could possibly avoid it, but for some people it ultimately does become necessary, so it is there for you. Let me see where I am. That's really the end of the... the rest of it is informational purposes on suggestions. And then we have, at the end, the Federation for Children with Special Needs, their website and sort of the trainings that they provide. SpedPac is obviously willing to do more trainings in specific areas if parents are interested in that. We just need to hear from you. And then there is a list of resources on here, some of which is part of what I said that we would send out directly at the end, but we will send out the additional resources that I referred to. So we're past our time. Thank you for coming, and I hope it was helpful.
Thank you.